everyone's ready, I'll call our final case, case number 67842 in the matter of Robert B. Evans III. I'll remind the parties again, this is a reciprocal discipline matter, which is an evidentiary hearing, so any exhibits need to be offered into evidence, and any witnesses need to be sworn in. I'll say what I started to say about the Keating case, which is the exhibits that were offered at the prior hearing have all been withdrawn. And so we're starting from scratch on admission of exhibits. So I'd ask that both parties readmit any exhibits they would like the court to consider. All right, will the parties announce their appearances for the record, please?
Amanda Cates on behalf of the Commission for Lawyer Discipline.
Gaines West for Mr. Evans.
Thank you.
And at the table with me is Mr. Evans, Robert Evans, and also my associate attorney, Melissa Kelch.
Thank you. All right, Ms. Cates, you may proceed.
May it please the board. This is a reciprocal disciplinary action brought pursuant to Part 9 of the Texas Rules of Disciplinary Procedure based on the misconduct which occurred in Louisiana of Robert B. Evans. This case was initiated when the Office of the Chief Disciplinary Counsel filed its original petition for reciprocal discipline with this board on May 4th, 2023. An order to show cause was signed on May 16th, 2023, requiring respondent to show cause within 30 days of the order why identical discipline should not be imposed. Respondent received the petition in order to show cause by email on May 16th, 2023. Thereafter, subject to many orders for motions for and orders on motions for continuance, we reconvened on January 26th in the instant matter, and the reciprocal discipline matter was called for hearing before this board. Petitioner, the Commission for Lawyer Discipline, appeared through its attorney and announced ready. Respondent Evans appeared through his attorney. The hearing on the petition for reciprocal discipline was ultimately continued to today, April 26, 2024. On or about January 27th, 2023, an order per curiam was entered by the Supreme Court of the State of Louisiana in a matter styled Supreme Court of Louisiana, cause number 2022-B-1439, styled in re Robert Bartholomew Evans III, attorney disciplinary proceeding, which states in pertinent part, upon reviewing the findings and recommendations of the hearing committee and the disciplinary board, and considering the record, briefs, and oral argument, it is ordered that Robert B. Evans III, Louisiana Bar Roll Number 23473, be and he hereby is disbarred, retroactive to September 28th, 2018, the date of his interim suspension. His name shall be stricken from the roll of attorneys, and his license to practice law in the state of Louisiana shall be revoked. All costs and expenses in the matter are assessed against respondent, with legal interest to commence 30 days from the date of finality of this court's judgment until paid. At this time, I'm going to go ahead and offer my exhibits,
Okay.
And I'll go through them individually, but they have all been submitted to Mr. West. Exhibit 1 is a certified copy of an order per curiam and the Evans matter from Louisiana. I'd offer that at this time.
No objection.
Exhibit 1 is admitted.
Exhibit 2, original certificate from Blake A. Hawthorne, dated January 3rd, 2024, which indicates that respondent is licensed and authorized to practice law in the state of Texas.
No objection.
Exhibit 2 is admitted.
Exhibit 3, a letter from Louisiana with the notice of disbarment of Robert B. Evans III.
It's a hearsay document unless there's some way that she can prove it up.
What's your response, Ms. Cates?
I am not necessarily offering the exhibit for the truth of the matter asserted in the document itself. The letter of the document is simply a letter from Louisiana telling us about the discipline, which is all pertinent and in all of the orders that are also submitted. So I'm merely offering it for the sake of showing that this is how we learned of Mr. Evans's discipline.
The objection's overruled and the letter is admitted. Exhibit 3.
Exhibit 4 is an email sent by respondent Mr. Evans with notice of the deposition of Carrie Doste and the transcript of said deposition.
No objection.
Exhibit 4 is admitted.
Exhibit 5, respondent Robert Evans's motion to exclude the testimony of Dane Cialino.
No objection.
Exhibit 5 is admitted.
Thank you.
Is this a motion he filed in the Louisiana case?
Correct.
Okay, thank you.
And Dane Cialino was previously his attorney to the best of my recollection.
Okay, thank you.
Exhibit 6, respondent Robert Evans's objection to the hearing committee report number 23 from the courts in Louisiana.
No objection.
Exhibit 6 is admitted.
Exhibit 7, respondent Robert B. Evans III's objections to the Office of Disciplinary Counsel's recommendation to the Louisiana Supreme Court.
No objection.
Exhibit 7 is admitted.
Exhibit 8, the complete trial transcript regarding Robert B. Evans III, file number 19-DB-013, dated January 6th, 2021 and January 7th, 2021.
No objection.
Exhibit 8 is admitted.
Exhibit 9, an email from respondent Robert Evans to the State Bar of Texas Membership Department, March 18th, 2023.
No objection.
Exhibit 9 is admitted.
And those are all my exhibits at this time. May I approach to give them to the,
Yes.
do you want a copy? You have them all. Did I give you the wrong ones?
You did, just one extra. 10 was it?
At this time, would the board like me to go ahead and go through my responses to the arguments made by Mr. West in his memorandum, or would you prefer me to wait until later?
It's your opening, so whatever you think you need to address now, if you'd rather wait and hear what Mr. Gain or Mr. West argues, you're free to do that as well.
I'll go ahead and give you so that maybe we can streamline this a little bit.
Okay.
In response to Mr. West's memorandum that he filed 10 days prior to the last hearing, which I did respond to and then filed an amended pleading, Mr. West makes several arguments on behalf of his client as the burden has shifted to Mr. West to make his defenses, as the Commission for Lawyer Discipline has filed a certified copy of the final judgment of discipline from the orders of Louisiana and therefore has met our burden for the reciprocal discipline. Mr. West argues that his client has been denied of due process, namely two different reasons he claims are that Mr. Evans's attorneys, prior attorneys who were representing Mr. Evans at the time that these actions occurred, that Mr. Evans's actions occurred, were subpoenaed and questioned by the Louisiana Disciplinary Council in violation of his attorney-client privilege. However, two different things here in response to that. One, Mr. Evans voluntarily waived that privilege as to several of the attorneys. One is Ms. Doste, as he noticed her deposition and asked her all of the questions about her underlying representation. He did file an objection to Mr. Cialino's testimony. However, the Louisiana appellate courts and the Supreme Courts heard that argument about the issues Mr. Evans had with that testimony and fully weighed in on it and said, it doesn't matter, that's not an appellate issue to go forward on. Additionally, and not in my briefing, but of importance here today, is Mr. West cites one Louisiana Rule of Professional Conduct 1.6, And he states that there is no exemption for the testimony given by the attorneys. There is, in fact, several rules within this rule that allowed the attorneys to testify, namely to prevent, mitigate, or rectify substantial injury to the financial interests or property of another that is reasonably certain to result or has resulted from the client's commission of a crime or fraud, in furtherance of which the client has used the lawyer's services. Let me explain how that fits here. Mr. Evans allegedly, or has found to have, misrepresent information in some underlying civil matters, in a civil dispute he had with his business partner. Therefore, the individuals who were called to testify as attorneys for Mr. Evans during that time period were able to give information about what they did or didn't do or advise him of that would have been in furtherance of those potential misrepresentations. Namely, one of Mr. Evans' defenses at some point during the Louisiana proceedings was that his attorney told him to do X, Y, or Z, or his attorney didn't tell him to do, and so he didn't know better. And so the attorneys came to give testimony saying, absolutely not, that's absolutely not the way this happened. And so that falls strictly within this provision, but also to establish a claim or defense on behalf of the lawyer in a controversy between the lawyer and the client. Attorneys were the lawyers, based upon conduct in which the client was involved, or to respond to allegations in any proceeding concerning the lawyer's representation of the client. If the attorneys that had been called and subpoenaed to question about Mr. Evans's discipline and his actions, if the disciplinary council in Louisiana had found out that those lawyers were part of that, they could have been subject to their own disciplinary actions. And so it was incumbent upon them to be cooperative at such an early stage so that they didn't end up in front of different courts on their behalf. We have the similar rules here in Texas, the analogous rules that allow attorneys to divulge information under 105, specifically 105C, 4, and 5, which specifically state they can respond to disciplinary actions. They can also, very similar to the 106 rules. In regards to an infirmity of proof, which Mr. Gaines, on behalf of Mr. Evans, argues that the courts in Louisiana didn't prove that Mr. Evans' conduct was intentional. The record from the Louisiana records are rife with the words intentional. They repeatedly state that he intentionally did these things. And so it's disingenuous to argue that the several different levels of courts, be it the committee, the Supreme Court, didn't all reiterate that they truly believed that all of these actions were intentional. I believe there's a final one, and give me just one moment. Grave injustice. Mr. West argues that imposing the identical discipline, which would be disbarment, would be a grave injustice. Mr. West uses this time to talk a little bit about the mental health, not a little bit, a lot of it actually, mental health of Mr. Evans during the time of his actions. The commission is not, these arguments do not fall on deaf ears by the commission. The problem is Mr. Evans, and as shown in the briefing in the transcript from the trial, Mr. Evans was expressly asked in 2020, I think I said in 2020, whether he had a disability at the time of the actions. And he, without question and in express terms, and you can see it in my briefing, I've done the snapshots of the transcript. I do not, nor have I ever had a mental disability. I was never encumbered by these things. And that's after the letter in 2018 that says he had these issues from the doctor whose testimony was also taken in a deposition subsequent for this proceeding.
I have to slow down a little bit.
I apologize. So to the best of what has been briefed and the best of the information that's presented, and inclusive of the deposition testimony from the doctor, and I will, to say something about the testimony of the deposition, I had the opportunity to question that doctor. I do not believe that he should be qualified to testify in this case or his deposition used in this case as an expert witness.
We can address that if,
I have to interject because she had an opportunity to file a subsequent motion to strike. The board gave her that opportunity. She never filed a subsequent motion to strike. Rule 21 requires 3 days notice before. I don't think she can argue that anymore. She has waived that.
and we can address that
Sure.
when you offer the testimony.
The doctor who was deposed, I believe his name is Chester, I apologize, there are a lot of names in this case. He admitted that he was not treating Mr. Evans during the time of the actions. So any information he could give on this matter is based on other doctors' notes, which we have not heard from, which we have not been able to question, which are not here to testify today. And so I think the board should weigh that testimony with all of those things in mind. It is the opinion of the commission that Mr. West, on behalf of his client, Mr. Evans, have not met their burden to show that any of the defenses have been met, and therefore he should be disbarred.
Thank you, Ms. Cates. Mr. West,
Yes.
you may proceed.
I'll proceed with a brief opening, and then we'll get into the exhibits.
Okay,
All right. The issue before the board is yet another example of another state and their attorney discipline system failing an attorney despite the obvious signs that the attorney is suffering from a disability. In the present case, the Commission for Lawyer Discipline has asked the board to impose reciprocal discipline on my client based on a judgment from the Louisiana Supreme Court disbarring him from practice there in Louisiana. However, the board will hear today reciprocal discipline is improper because Mr. Evans will establish one or more of the defenses under 904 A, B, C, D, and E. The board will hear testimony from Mr. Evans' psychiatrist. It'll be by deposition testimony that's been provided to the board, Dr. Charles Chester. Dr. Chester was here the last time we met. He moved to Hawaii and was unavailable to come, and that's why we took his deposition. Through Dr. Chester's testimony, the board will learn that in the summer of 2018, Mr. Evans suffered from a disability due to several psychiatric and non-psychiatric medical conditions, including then an undiagnosed bipolar disorder. Dr. Chester will also explain that based on medications that Mr. Evans was prescribed at that time, he could not exercise reasonable judgment. Similarly, Mr. Evans could not formulate the necessary intent to engage in the alleged conduct, which forms the basis of the Louisiana disciplinary matter. Finally, the board will hear how Mr. Evans has thrived since his bipolar disorder has been accurately diagnosed and treated. Ms. Cates made great to-do about the fact that my client tested to the Louisiana board that he was not disabled. Dr. Chester specifically opined, as the only expert in this matter, that my client could not have made that statement knowingly because he wasn't capable of being able to diagnose himself as being disabled. The board will hear from Mr. Evans, who will provide testimony related to the lack of that procedural due process that Ms. Cates referred to. You'll hear that how the Louisiana Office of Disciplinary Counsel intentionally violated Mr. Evans' attorney-client privilege, wrongfully obtained evidence against Mr. Evans, and systematically denied Mr. Evans the opportunity to confront his accusers or respond to their allegations. Moreover, the board will hear that upon a finding that respondent has established one or more of these defenses, that he should be not disbarred, that as you fashion the correct reciprocal discipline, that you consider what he is offering as an 18-month fully probated suspension. What that will do will allow you to have a strain on him to know what's happening in his practice life. If that there's a problem with his practice, then Ms. Cates can bring it to the attention of the board, and you can bring him back in here and have him respond. But the nature of these defenses, we believe, will come out in Mr. Evans' testimony. And with that, I would like to go ahead and offer exhibits into the record.
Before you do that, I have a question. You said that Mr. Evans wasn't qualified to provide an expert opinion about his mental health in 2018.
Not only not qualified to make an expert opinion, but qualified to self-identify as being disabled.
But isn't a litigant always competent to state what defenses they're raising or what issues they're putting before a tribunal?
Not if they're disabled or not, no.
Well, he testified before the board in 21, right?
No,
In
it was
Louisiana?
2021, yes, that he wasn't disabled at the time. But he had no way of being able to determine that because of his disability.
Well, Dr. Chester testified that the disability had significantly improved by 2019, certainly,
had.
and certainly by 2021,
It
correct?
had. But the activity occurred in 2018. And when he went back and said at that time, I wasn't disabled, there was no way, Dr. Chester believed that he wasn't capable of making that determination.
Right, but he was capable in 2021 of deciding what defenses or positions he was going to take in the disciplinary proceeding, isn't that right?
In Louisiana,
Yes,
yes, correct.
all right. You may introduce your exhibits.
Thank you. Exhibit 1, which you have copies of all these exhibits, will be the deposition testimony of Charles J. Chester. We would move that deposition be accepted into evidence in this matter.
Ms. Cates?
And I would object to this particular exhibit because it's being offered essentially as expert testimony. Mr. West even lists Dr. Chester as an expert witness in his witness list. And the problem with that is there has not been enough information given by Dr. Chester, either in the deposition or he was here last time, to tender Dr. Chester as an expert for multitude of reasons, but not least of which is that in the deposition, he admits that he was not actively treating Mr. Evans at the time that these diagnoses were in full swing and going on. Therefore, it's just improper for it to be taken as an expert witness testimony.
The objection's overruled. Exhibit 1 is admitted, and I've reviewed the objections within the deposition, and they are all overruled.
Exhibit 2 will be the unsworn declaration of Charles J. Chester.
Ms. Cates?
No objection.
Exhibit 2 is admitted.
Exhibit 3 is the CV for Charles J. Chester.
Ms. Cates?
No objection.
Exhibit 3 is admitted.
Exhibit 4 is the report from Charles J. Chester, dated 4/13 of 19.
Your exhibit list says 4/3/19.
4/3/19, I apologize.
No objections.
Exhibit 4 is admitted.
Exhibit number 5 is the business records affidavit and report from Bradley J. Bartholomew, MD, dated 6/22/18.
I object as this individual is not here to be cross-examined. This individual has not provided any other information. So I think at this time it is improper for it to be admitted as an exhibit.
Yeah. Your objection's overruled. Exhibit 5 is admitted.
Exhibit number 6 would be report from Sunil Jolly, MD, dated 6/22/18.
Say the name again?
Sunil, S-U-N-I-E-L, Jolly, J-O-L-L-Y, MD, dated 6/22/18.
Your exhibit list has an S-U-N-E-I-L.
S-U-N, I had I-E-L, but it may be E-I-L. Could be one or the other.
I have the same objection as to the Bartholomew report.
What purpose are you offering this for, Mr.?
Well, it's a third-party business record, and we have authenticity is proved up by 90210, the business records exception. And 8036, it's records of regularly kept in a business activity, and 8034, statement made for medical diagnosis or treatment.
May I respond to that?
Yes.
There is no business records affidavit. There is no information stating that this is in fact a business record. Therefore, it is not properly proven out for the purposes of authenticity.
The affidavit was the unsworn statement by Dr. Chester included this letter, and he can prove it up through his unsworn statement as a third-party business record.
Where in Mr. Chester's statement did he prove up this letter? And is that exhibit number 2?
It is exhibit 2. You'll see his unsworn statement, and you'll see that Dr. Jolly's letter is contained in that unsworn statement. In the copy of the unsworn statement, the third-party statements are included in the third paragraph of his unsworn statement. In addition, Robert Evans was my patient, and I have personal knowledge of the documents kept in Mr. Evans' patient file, which I have maintained under my supervision and control. Attached are 3 pages of records, which were incorporated and kept in the course of the company's business.
I'm sorry, which are what?
Which were kept in the course of the company's business. That is proving it up through his unsworn statement. And Dr. Jolly's letter is in that.
It's not attached to exhibit 2 that you
It
admitted.
is, it is.
Don't believe it is. It's not attached to what we have, to exhibit 2.
I can. Dr. Bartholomew, Dr. Jolly, and Dr. Penny's letters are all attached.
They're not in the exhibits that have been submitted to the board.
Okay, then I would like to do a trial exhibit because I have them in mind. It just had to have been an error that it was left out because he refers to them in this paragraph as the 3 pages of records.
But he doesn't state what they are.
He says that, which were incorporated and kept in the course of the company's business. So these were all records in these are the only 3 pages that it could refer to that were in his business record.
I'll admit exhibit 6 for the purpose of it being in Mr. Chester's
Unsworn
file.
statement.
Yes, but not for the truth of whatever might be stated in the letter.
The other, I think the other way you could accept it is because it's an exception to the hearsay rule, because it is a document that is a statement made for medical diagnosis. That's 8034.
It's not the statements made for the purpose of the diagnosis, it's actually the diagnosis, isn't it?
Well, it's made for the medical diagnosis, part of the medical diagnosis.
Same ruling. I'll admit it for the purpose of it being attached to the Chester declaration and referred to therein, but not for the truth of what's in the document.
And then Exhibit 7, the business records affidavit and letter from Gary L. Penny, MD, dated January 17th of 24. And there is a business records affidavit there.
Ms. Cates, any objection?
No objection.
Exhibit 7 is admitted.
And that's all I'll refer to now. There may be 2 other exhibits, but may not have to get into them.
All right, thank you.
Thank you. Would you like me to proceed with my?
Yes, please call your first witness.
Yes, I would call my client, Robert Evans. If I keep my voice up, would it be all right for me to sit while I'm examining him, or would you rather me at the podium?
I think it's easier for us to hear if you stand at the podium, if that's okay.
Absolutely, no problem. Please.
Mr. West, as I'm sure you understand, we are not here and we can't retry the underlying disciplinary action. So if you'd focus your direction and your
It'll be on the
arguments
defenses.
on the defenses, correct?
Yes. State your name for the record, please, sir.
Robert B. Evans III.
And what's your involvement in this proceeding?
I am the respondent.
Be sure you keep your voice up.
I am the respondent
Where are you currently living?
in Fair Oaks Ranch, Texas.
Do you have children?
I have 5,
What are their ages?
25, 19, 18, 15, and 13.
Got a full stable there.
Oh yes, 14 age boys at one time.
Where'd you get your undergraduate degree?
Loyola University of New Orleans.
What other degrees do you have?
I have a master's in business and a law degree.
Where'd you go to law school?
Loyola University of New Orleans.
And where'd you get your MBA?
Loyola University of New Orleans.
And when did you become licensed to practice law in Louisiana?
In April of 1995,
What about when you became licensed to practice law in Texas?
December of 2001.
Are you licensed to practice in any other jurisdiction?
No, sir.
What areas of the law do you primarily practice?
I've always had a general practice law firm, but mainly personal injury.
Excluding this disciplinary matter at issue today, have you ever been the subject of any disciplinary actions brought by the Louisiana or Texas bar?
Never.
And you became licensed in Texas when?
2001.
So prior to the underlying Louisiana disciplinary matter, you have no disciplinary history at all?
That's correct.
During your almost 30 years of practice, have you received any recognition from your peers?
I've been AV rated by Martin Del Hubble for at least 15 years. I was named top litigation attorney in the country by the International Association of Top Professionals in 2018. New Orleans Magazine named me top attorney in commercial litigation and personal injury litigation in 2017 and 2016.
Now, the board has read the deposition testimony of Dr. Chester and regarding your medical history, but I'd like to hear from you so that you can tell the board and explain the different medical issues you were dealing with during the spring and summer of 2018, which formed the basis of your difficulties that you had in Louisiana.
I was in extreme distress because I couldn't urinate, and I had already had a back fusion from a car accident, and my neurologist was telling me that I was going to be paralyzed if I didn't have another surgery right away. And it turned out that I had shingles, and he couldn't do the surgery because I had this infection, and he had to wait for the shingles to heal before he could do the new fusion to enable me to urinate.
What impact did your physical and mental health have on your family?
Oh, tremendous impact. I became very erratic because I was very upset that I needed another fusion. I had one already in 2014, and here I was in 2018 being told I needed to go through it again. And it was the hardest surgery I ever had to go through in my life. I've had 45 surgeries, and by far, that's worse than the heart surgery that I had.
Was there a period where you were unable to work due to the compressed nerves in your spine?
I actually took off 8 months in the summer, and I continued everything that I had, waiting until after I had the surgery, not knowing it would be 6 months till the shingles went away.
Now, briefly, if you would, tell the board about this situation that Ms. Cates brought up about John Litchfield and Carrie Dast. Briefly.
As Carrie Dast testified, her deposition offered in, by Ms. Cates, she says at page 217 through 220 of her deposition that from the very time I hired them, she did not trust me and did not like me, and they didn't disclose that to me, that yet they took the case, and she still worked it with her boss. And this wasn't the first issue where she lied in a pleading. She actually lied in a pleading earlier and got a motion for contempt filed against me because of something. So what happened here was she told me in an email she was going to file a motion, and she'd been telling me that for almost a year. They were sitting on my case, delaying it. Finally, when I was going through this manic period, being told I needed surgery, and I was up and down all over the place, she told me she sent me an email with the number she was going to file a motion to withdraw the money from the court. Well, I finally called her, emailed her, left her voicemail, she didn't respond, so I filed the motion that I thought she told me she was gonna file. And it turned out that she never did talk to the other lawyer to get his consent to that. So
So-
I filed an ex parte motion versus setting it for a contradictory hearing.
So regarding the motion that you filed, what was this for?
It was to withdraw money from the registry of the court that my former law partner owed me.
And you filed this motion instead of your attorneys?
Correct.
And why?
Because they were completely ignoring me.
What did your attorneys say they were gonna do?
They said they were gonna file a motion for summary judgment and a motion to withdraw the funds for 8 to 10 months before that.
How did the opposing party respond to your motion?
They filed a motion to rescind the order, but I agreed to return the money. And in fact, the judge who heard the case did not hold me in contempt and did not punish me in any way. She understood it was a misunderstanding, and I put the money back in the court, and there was no harm done.
Did Mr. Litchfield or Ms. Dass continue to represent you in the lawsuit after you filed the pro se motion?
They filed a motion to withdraw, but they were still enrolled as my attorneys when, to my surprise, they received a subpoena by the Louisiana Office of Disciplinary Counsel to take their depositions. And even if an exception applied, I was still entitled to get notice beforehand to assert to the court so I could file a motion to see whether the exceptions applied. And I
You
was
weren't
never
given
given that opportunity.
When you received the initial complaint, was this also during the time that you were scheduled to have your spinal fusion?
Yes.
Was it abnormal for the opposing party or his counsel to file a complaint against you?
He was filing multiple complaints against me. In fact, before I even filed this motion, he filed a 30-page complaint against me that was totally disregarded by the Office of Disciplinary Counsel.
When were you notified that new allegations of misconduct were brought against you?
Probably when I was getting ready to have the surgery in October of 2018.
Did you have an attorney representing you in the disciplinary matter?
Bain Cialino, yes, professor at Loyola.
Okay, now, if you recall in Respondent's Exhibit 6, it's a letter from Dr. Jolly. Can you remind the board who Dr. Jolly is?
Dr. Jolly was my pain doctor at the time, and he had installed a dorsal column stimulator in my back. I still have that today, but he was treating me for pain pending the surgery.
And that you would need, what, 6 to 8 weeks to recover?
To recover post-surgery, correct.
Was Dr. Jolly responsible for your recovery plan?
Yes, the pain management portion.
In addition to her letter dated June 22nd, 2018, Dr. Jolly stated that you must not work from that date of her letter through your back surgery. Is that right?
Correct.
Dr. Jolly stated that you would be medicated during your 6 to 8 week recovery period. Do you remember that?
Yes, I was actually medicated before the surgery with pain medicine.
And when did that spinal fusion occur?
The second spinal fusion didn't happen until October after the shingles was cleared.
What was your recovery like in surgery, from surgery? What was your recovery like from surgery?
It was a difficult recovery. Fusions are difficult. It took me at least 6 weeks.
So from June 22nd of 2018 until at least November 15th of 2018, you were recovering from shingles, undergoing your spinal fusion surgery, and then recovering and rehabbing from surgery. Is that right?
Able to urinate and passing blood.
Despite Dr. Jolly's clear instructions that you were not supposed to be working, were you still expected to respond within a specific time to the complaint filed against you?
Yes, it was.
Did you notify the ODC about these medical conditions that you were struggling with?
Yes, we did.
When did you learn that the ODC was investigating you based on this incident?
I think it was March of 2019.
How did you discover that you were the subject of an ongoing confidential investigation?
Received a letter from disciplinary counsel.
Did you meet with the ODC?
I met with them and I voluntarily gave a statement, yes, and then that's when I first learned that my lawyers who were representing me secretly gave these statements against me.
Were you or your lawyer, Ms. Cialino, provided notice of the investigation?
Mr. Cialino was not given notice and I was not given notice.
Did you receive notice of a copy of the subpoena that was sent to Litchfield and Dass compelling them to testify against you? Sorry?
Asked.
Did you receive notice of a copy of the subpoena that was sent to Litchfield and Dast compelling them to testify against you?
No, did not receive a copy.
When you went to give your statement, did the ODC disclose to you that your attorneys had already provided sworn statements?
I was not told until during my voluntary statement in, I think it was January or February of 2019, when I first learned about the charge against me, and I voluntarily gave this statement. I thought I was the first one giving any information about it. Little did I know that my lawyers had already secretly given statements while they were still enrolled as my attorneys.
If you had known about that, would you have terminated Litchfield and Dast?
Oh, absolutely. In fact, I would have filed a motion with the court to stop it.
Had you given Litchfield and Dast permission to disclose privileged information?
Exactly the opposite.
Did Litchfield and Dast representation, were you engaged in any fraudulent or criminal activity?
Not at all.
Did you seek to obtain either of their legal services for the purposes of committing or furthering a crime or fraud?
Not at all.
After you discovered that your attorneys had disclosed your privileged information without your knowledge or consent, did you attempt to object to the ODC's use of their testimony?
Yes, I did.
And what was the ODC's response?
ODC's response was it didn't matter. They already had the testimony and they were going to use it against me.
Did you feel you were given a fair opportunity to defend yourself and present your case in the
No.
Louisiana disciplinary
What
matter?
happened
Hold on,
was-
just let me ask the question. Do you feel that you were given a fair opportunity to defend yourself and present your case in the Louisiana disciplinary matter?
No, sir. What happened was whatever Kerry Dast said is what the board took as the law, and they were unaware of the lies she had committed before, and then her deposition testimony offered, where she admits that she never liked me from the day she hired me, and they never disclosed that fact to me.
Do you,
Ms. Gates has an objection.
I'm sorry.
I believe.
I would just ask for Mr. Evans to be instructed that Ms. Dast is not on trial and she is not here to defend herself. And so to keep it to, you know, what he's making his defenses about rather than.
I think this does go to his defense, so
Yeah.
objection overruled.
thank you.
I apologize. I only reference it because she offered the exhibit, the deposition, so I felt obligated to.
Do you recall the day you filed the ex parte motion to withdraw funds?
I do.
What day was it?
June 6th of 2018, it's when I was already told from doctors not to work and I was disabled. I was manic, I was up and down. I was unaware of how I was acting. I called Ms. Dast several times, she didn't answer. I left her voicemails. She could tell I was in distress. She admits that in her deposition. I sent her emails to go file the motion she promised to file. She ignored the emails. So I told her I was gonna file the motion, and she ignored that. So I filed the motion, and even after I filed the motion, she waited until the other party objected when they learned about it. 10 days later was the first time she contacted me about it.
Today, do you maintain that you did not knowingly make any misrepresentations to the court?
I did not knowingly make any misrepresentations at the court.
Okay, what was-
I do take full responsibility for filing the motion, because what I did was I filed an ex parte motion believing what she told me was true. So it's my fault for believing somebody that told me something that I shouldn't have believed. And now the lesson I learned is I won't file a motion unless I'm the one who gets the confirmation from the third party.
But you also learned something else about what was going on that week, didn't you, afterwards?
Yes.
What'd you learn?
About what? In regard to,
Your emotions.
about me getting committed to the hospital?
Yeah.
Well, I was determined to be suicidal by the emergency room for the back pain
So that was going on during the week of June 6th?
days after.
Was your family there with you?
Yes.
Did you go on vacation after that?
No, they went on vacation without me. It was the first time they'd ever gone out of Florida without me.
Can you describe to the board then what your physical and mental health was like during the spring and summer of 2018?
I was basically coiled up on the floor of my closet, depressed, in pain,
you were on pain meds, muscle relaxers, Adderall, alprazolam, and Valium. Is that right? Anything else?
They were hoping that the muscle relaxers and the Valium would help the urination happen so my bladder would go through because of the nerve, but that didn't help.
How did you respond to these medications?
Well, they made me even more erratic, I guess, with my manic episodes I was having. I didn't realize.
You didn't know they were manic? You didn't know that at the time?
No, I didn't.
Did you feel like your medications were improving your mental health?
No, I was completely depressed, and I was doing horribly at the time, but I was hoping the medicine was helping at least with the pain and for me to be able to urinate.
Do you think your undiagnosed bipolar disorder affected your behavior during that relevant time period?
Absolutely.
In what way?
Well, I think it caused me to act erratically and file a motion instead of waiting for my attorney to do it. And I should have confirmed with her the statement that she made that the other lawyer consented to the motion. But I take responsibility for it. I filed it.
Did Dr. Chester testify that just a few weeks after you filed that motion, you were hospitalized for psychiatric treatment?
Yes.
Can you explain to the board the events that led to your hospitalization?
I was in severe pain. I couldn't urinate. I was passing blood. And I went to the emergency room at Oxford Hospital, where my brother's a doctor. And I was hoping that the ER would put me in a surgical room and let the neurosurgeon do the surgery on me. And they told me it wasn't going to happen that way, that I had to schedule an appointment. And during the conversation, I mentioned to the nurse, I said, I'd rather die than have another back fusion. And he said, oh, now you gotta have another doctor come in and do an evaluation of you. So he did an evaluation of me and determined I was possibly suicidal. And since I had a gun at the house, he said, okay, you're getting admitted.
So in Dr. Chester's testimony, he said that due to your undiagnosed bipolar disorder and the medications you were taking in June of 2018, you were mentally disabled. Would you agree with that statement?
Now, I didn't understand when I testified at the hearing that was considered a mental disability, but I understand that he terms it as a mental disability.
And looking back on it now, do you believe you were disabled at the time?
I do. I understand now, yes, very clearly. In fact, once I got on the medicine, it helped me so much that it was clear for me to see how erratic I was behaving.
In the petition for reciprocal discipline, there is an exhibit, and it reads that respondent suggested that he suffered from generalized anxiety disorder and depressive disorder, in addition to physical health problems, including chronic back problems, that necessitated the use of narcotic medicine. Nevertheless, respondent specifically denied he suffered from a mental disability or chemical dependency during that time frame in question.
I think it was a compound question. I denied that I was had a chemical dependency issue, but I was certainly, now I know, had a mental disability at the time, this undiagnosed bipolar.
And you recall denying that you suffered from a disability or chemical dependency, right? This looks to be based on a statement you made before you were diagnosed with bipolar disorder. Is that right?
Probably, yes.
Do you feel like you could accurately assess your mental health status at that time?
Not at the time, no.
Did the ODC ever discuss with you the status of your mental health?
Never.
Did, after you were diagnosed with bipolar disorder, did your psychiatrist change your medications?
Oh, yes, he put me on bipolar medicine, which changed my moods almost within a week.
So it changed almost immediately?
Yes.
Looking back at your behavior, the condition of your physical and mental health, and your undiagnosed mental illness, do you believe that you were suffering from a mental disability in June of 2018?
Now I know that I was, yes.
Are you still seeing a psychiatrist?
I still am, yes.
Who?
Dr. Gary Penny here in San Antonio. I'm sorry, in San Antonio.
When did you move to Texas?
June of 2020.
Since your move, have you been practicing full-time?
I practiced full-time as an employee for Jason D'Souza from June of 2020 until he wrongfully terminated me in
So in the time that you've been practicing in Texas, have you had any issues representing your clients?
None at all.
In the time that you've been practicing in Texas, have you had any issues representing your clients?
None at all. In fact, I've received rave reviews. In fact, Jason D'Souza told me how the clients love me. And I've received referrals from the clients. I've received referrals from employees of his firm that he doesn't even know about.
Now, you've not been the subject of any disciplinary proceeding in Texas, have you?
None at all, except for this.
You said you were wrongfully terminated. Go ahead and tell the board why.
He was demanding that there was an individual we were representing, I don't want to say his name out of confidentiality, but there was an individual we were representing that he lost part of his thumb in an oil accident, and he was on THC at the time. He tested positive, and Mr. D'Souza demanded that I go represent this individual in Duval County, a couple hours away, on 8 attachments and warrants that he had in criminal matters, even though that wasn't part of our contract. So when I questioned him about what the arrangement was, he got so mad, he pulled me off the file, and then when I said, okay, you're pulling me off the file, take me off the file. Then he says, now I accept your tender of resignation. I'm like, what are you talking about? I didn't tender a resignation. So he made up this tender of resignation.
So who are you working with now?
I just have my own, the Evans Law Corporation.
Okay. And so you started your own practice?
Yes,
Okay. Hadn't had any problems doing that?
none at all.
And what do you owe that to? What do you think is the reason you're not having any problems now?
Well, I'm getting treated on the medicine that I'm supposed to be on,
And you take it
I
regularly?
regularly see my doctor. I saw him last week. I see him again in 4 weeks. And I'm also in counseling. I have a counselor I see at St. Peter and St. Joseph Church.
Let me ask you this. You have recommended to the Board of Disciplinary Appeals that if they would be willing to suspend you from the law practice, you've asked them to give you a fully probated suspension so you can continue to practice law, but you've asked them to probate that for 18 months. Why are you suggesting that?
Well, I've already served the 5 years in Louisiana. I'm past that now. In fact, in 2 weeks, I have the hearing to get readmitted in Louisiana. But if I get this bar here in Texas, it's going to kill me reputation-wise and business-wise, and probably bankrupt me. And in fact, I've lost my marriage because of this situation. My wife couldn't handle the stress of the constant battle in Louisiana and then here in Texas.
Okay. Pass the witness.
Ms. Cates, do you have any questions?
I do, thank you.
Good afternoon, Mr. Evans. When did you tell the State Bar of Texas about your discipline in Louisiana?
It was probably in March because I waited the 60 days for me to appeal the decision of the Supreme Court. And then I think I sent the notice in.
And how did you do that? How did you inform the state of Texas?
I don't remember if I sent a letter or sent an email.
Can I show you what has been previously entered as Exhibit 9 in this? May I approach?
Yes.
Have you seen this document, Mr. Evans?
No, ma'am.
Okay. Do you have any reason to believe that what is, the back is a different thing? That itself is a record of you reporting to membership of the State Bar of Texas your discipline?
I have no idea what the records of the Bar Association look like, so I can't say. I'd be speculating.
Okay, well, the comment here says, I was once a member of the Louisiana State Bar. However, in 2018, I was very ill, and I filed a motion ex parte instead of setting it for contradictory hearing. I misunderstood the advice of my counsel. However, I just learned on January 31st, 2023, that the Louisiana Bar temporarily disbarred me from September 2018 to September 2023. I am eligible to reapply in Louisiana in October of this year, 2023. I have just decided not to appeal, so this is final, and I will reapply. My Bates is over that, but reapply. Did you write that statement?
Yes. And I've reapplied.
When you say, I misunderstood the advice of my counsel, what are you meaning there?
Well, I didn't file this motion, I didn't make it up. She sent me an email telling me she was filing a motion to withdraw $207,000 from the court registry, and she had talked to opposing counsel about it, okay? When she gave her secret deposition to ODC in Louisiana, she never told them about the email. She just said, I never talked to Robbie about that. So she clearly lied to ODC because she never mentions the email where she says, I'm going to file a motion to withdraw $207,000 from the court. So she lied to them and never disclosed it. And it wasn't until I gave my statement and I said, here's the email she sent me. She actually said she was filing the motion. That's where it came from. And I just misunderstood that she thought it was, I thought she said it was ex parte, but the other side agreed.
When you filed that motion, you signed a certificate of service and an affidavit saying that you would provided a copy of that document to all of the parties, right?
I signed it, gave it to my secretary to do that, and apparently she did not.
Who's she and what did she not do?
Doris Nastis was given the pleading to file, and she did not file it or send it to opposing counsel.
And as the attorney in that matter was, well, and you weren't the attorney in that matter, right?
No, it wasn't the attorney.
But you filed it with your signature, right?
I filed it with my signature, and then after I gave it to her at the office and said, here, send this to opposing counsel and all counsel, I went home because I was sick, as I was saying, unable to urinate, passing blood, and in severe pain, and I had shingles.
Well, did you follow up at all to see if the copies had been sent to the appropriate parties?
No, I believe my secretary would have done what she always did.
So you say here, back to Exhibit 9, I just learned on January 31st, 2023, that the Louisiana bar temporarily disbarred me from September 18th to September 23. What do you mean when you say temporarily disbarred?
It wasn't a permanent disbarment.
And that's an option in Louisiana, right?
Permanent disbarment, yeah. They did not permanently disbar me.
But they did consider it, right? That's in the records?
I think a couple of them said, yeah, permanent disbarment, but the majority said no.
But it was a
And now
really,
I'm eligible.
right, and it was really close, right? It was like 2 to 3 or like,
No.
okay. But when you say you just learned about this, you had known since 2018 that you were on what we would call an interlocutory suspension, right? You were suspended in Louisiana from 2018.
I voluntarily consented to the suspension because I was so ill at the time and unable to defend myself at the time. So I consented to the suspension. It was not a final order or a final judgment that I was required to notify Texas about.
You don't believe that you were required to tell Texas about it?
The rules do not require me to file it unless it's a final judgment.
Why did you leave Louisiana?
I was offered a position with Jason D'Souza's office.
Was there any other reason?
Well, obviously I couldn't practice in Louisiana.
Do you, if you are reinstated in Louisiana, do you anticipate moving back to Louisiana?
Hopefully not. I hope to keep my license here and to continue to live here and practice here.
Are you currently the subject of any other potential disciplinary proceedings?
Objection, Madam Chair. We've not been notified that there's a line of cross-examination. No one has provided any information.
She just asked a question. Objection overruled. I think he's already answered.
Okay.
I'm aware of anything ongoing.
Are you aware of the ongoing unauthorized practice of law issue that's going on in North Carolina?
There's nothing ongoing in North Carolina. North Carolina admitted me to the bar, and I have a bar number. So I'm a member of the bar in North Carolina.
Well, let's talk about that. What is your understanding of the bar number you have in North Carolina?
I understood at
Madam
the
Chairman,
time.
again, this is a subject that's not a part of their claim. If they want to pursue him on another matter, that this is not part of the reciprocal.
Ms. Cates, what's the relevance of this to the question before the board right now?
Well, currently I've asked him if he's the, I guess, recipient of any other ongoing disciplinary matter, and he said no. So now I'm asking information to corroborate whether that is a truthful
I
statement or not.
understand, but But what's the relevance of the issue to what we're here to talk about today?
Well, I think if the panel decides, if the board decides that there is discretion to offer Mr. Evans something other than reciprocal, what would be as identical as is practical, which we are arguing is disbarment, then I think that I should be able to give evidence that would serve as a mitigating or aggravating factor that would influence the board to be able to make a decision as to what they wish to do in their discretion.
So you want to talk about a pending investigation that hasn't resulted in any final ruling?
Actually, my understanding that just recently it did result in a final ruling.
Well,
I don't have any knowledge of that, and if she has knowledge of something like that, she should provide me that information.
I think this is outside the record of what has been presented to the board, so I'll sustain the objection.
Then I have no further questions. Thank you very much.
Okay. Does the board have any questions?
Mr. Evans, what is JLAP, J-L-A-P?
Judges and Lawyers Assistance Program.
You go through that in Louisiana?
I voluntarily went through that program and completed it successfully, yes.
Who's Jennifer Gross?
Jennifer Gross is an employee who helps run JLAT for Louisiana.
She's
She's just an employee. She's not a doctor, she's not a nurse, she's not a lawyer. She's just an
she
employee.
could bring the records from JLAP, I presume. She could bring the records from JLAP.
No, those are confidential, not subject to release.
Well,
Fact, they're irrelevant.
in your hearing in Louisiana, the disciplinary council said that they wouldn't call Ms. Gross from JLAP unless you said that, unless you contended you were suffering from a mental disability or a chemical dependency that caused the misconduct.
No. What they
I'm looking
say-
at page 34 of the transcript.
Right. Don't mix up mental. It says drug or alcohol.
Does
is
mental
JLAP.
disability or chemical dependency?
No, it's mental or physical disability or drug and alcohol.
I'll refer you to page 34. I've just read it. It's in evidence. So isn't it true
I'm not
that,
alleging that drug or alcohol was a causative factor in my conduct.
you testified that you didn't have a disability because Ms. Gross or JLAP would have debunked that? Is that what you're saying?
No. She can't say anything about that. She's not a doctor. And none of the doctors actually said, the doctors that I saw through JLAP never said that I wasn't disabled.
Because that wasn't an issue that you brought before
I
the
didn't
Louisiana.
claim drug or alcohol was related to my conduct.
Or a
I
mental,
alleged that it was a mental disability, or at least Dr. Chester did.
Mr. Evans, when you testified before the Louisiana ODC, that was in January of 2021, correct? And by that time, the mental issues that you were having in 2018 had been largely resolved, isn't that right?
Yes,
And you were represented by counsel at that hearing in 2021?
I was.
And
And
wasn't
let
it?
the record reflect that was not me.
Yes.
Thank you.
Thank you. And you specifically were asked if it was your position that you did not suffer from a mental disability or chemical dependency during the time frame at issue, and you said, I did not. Isn't that right?
That's a compound question. It says mental disability or substance issue. And no, it should have been objected to. I did not have a chemical dependency issue. I had a mental disability issue. So it was an improper question.
Weren't you given every opportunity to raise the issue of a mental health issue or a mental disability at the 2021 hearing?
Dr. Chester provided his letter to the board, and that was admitted into evidence.
I had one other question. You said you blame the filing of this motion on a misunderstanding, and I want to make clear, did your lawyer ever tell you that she had conferred with opposing counsel or that they agreed to the motion?
She sent an email to that effect, yes, ma'am.
I believe the email just said she was going to file a motion, correct?
She was gonna file a motion to withdraw $207,000 from the court, the registry of the court, after conferring with opposing counsel.
Did she ever say that she had conferred and that they agreed?
She said after conferring with opposing counsel, she intended to file the motion.
Okay, so did she ever say that she had conferred and they
She told
agreed?
me that in the phone conversation after the email. And that's why I was so upset that another 10 days went by and she hadn't filed a motion.
Any other questions by the board? All right, any other?
I do want to point out, just to clarify on your question, what he was referring to was Exhibit 4, which was the letter from Dr. Chester that was considered at that 21 hearing.
Yes.
Thank you.
Any other questions by either party? All right, you're excused. Any other evidence, Mr. West?
No, Your Honor.
All right, I think we understand the parties' positions, but if you would like to take 5 to 7 minutes to do a closing argument.
It can be even shorter than that. It is the position of the Commission for Lawyer Discipline that we have met our burden by filing the appropriate final conviction documents, and that Mr. West, on behalf of his client, has failed to meet his burden to prove any of the defenses as available under the statutory language, and therefore the discipline, which would be as identical as is practicable, is to disbar Mr. Evans here in Texas. Thank you.
Thank you. Mr. West?
Thank you. Based on our evidence that we presented to the board today, I believe it's apparent that the Louisiana State Bar failed Mr. Evans. Instead of recognizing his disability and attempting to rehabilitate him, as we do here in Texas, they issued the most severe sanction against Mr. Evans while simultaneously denying him due process rights and failing to present adequate evidence to support the allegations of misconduct against him. As Dr. Chester explained, Mr. Evans did not knowingly violate any rules of professional misconduct. Mr. Evans had a disability and he needed help, which he fortunately received despite his treatment in Louisiana. As such, the imposition of reciprocal discipline against Mr. Evans is not warranted, and it would result in a grave injustice. The Texas disciplinary system should focus on supporting attorneys like Mr. Evans. Should focus on supporting attorneys like Mr. Evans, who are actively engaged in a treatment to seek to overcome their disabilities. Mr. Evans works every day to maintain his physical and mental health while simultaneously serving his clients and the community that he serves to the best of his abilities. For these reasons, the petition for reciprocal discipline should be denied. The evidence shows that the respondent was suffering from a severe mental illness during the time that the alleged misconduct occurred. Today, attorneys are inundated with messages from local bar organizations, state bar presidents, and the Supreme Court about the importance of mental health. Additionally, the Supreme Court and the Court of Criminal Appeals have created the Judicial Commission on Mental Health, and the legislature has established mental health courts. All of these efforts suggest that we should take mental health issues very seriously. To me, it is clear that Mr. Evans' mental health issues were not seriously considered by the Louisiana Bar. However, BODA now has that opportunity to appropriately consider his mental health and how his mental health relates to his level of culpability. Based on the evidence we presented today, I implore you to consider his mental illness and not hold him responsible for his alleged misconduct. If, however, the board determines that the respondent should be disciplined, I'm asking that he be given a suspension and that suspension be fully probated. He has rehabilitated himself because of the medicine that he's taking now. He has been diagnosed with bipolar. He is taking medication to prevent this disease to ravage his body like it did in 2018 and the months following that June period where he had so many problems. Mental health issues are difficult. You know, if you have a broken arm, we all recognize it. If you have a broken leg, you know, you have to have crutches. Mental health issues are not capable of being addressed that way. My client could not self-diagnose, which is really very common for people who have bipolar disorder. They don't realize the problem that they have, and they can't self-identify that and seek help. Fortunately, Dr. Chester was found. Fortunately, he was able to get the help he needed. And when he began practicing here in Texas after he was disbarred there, he's had a remarkable period of representing clients without discipline problems, without any issues. So, for those reasons, we believe it is appropriate to go ahead and let him practice law on a probated basis of suspension, so that if there are any problems, you'll be the first to know about it. I assure you, Ms. Cates is a very good prosecutor, and she'll bring any issues to your attention, should he have any. I don't think he will. He's now being cared for regularly, and he's taking his medicine appropriately. And if you have any friends or family members that have suffered from this terrible disease, you know, you're just, you know, you have to stay on that medication. He's doing that. He's shown that he can do it successfully, and that's what we ask you to do.
Mr. West, you said that you don't believe the Louisiana disciplinary system took his mental health issues seriously, but you know, in 2021, 2.5 years after the incident, after he had started seeing Dr. Chester and he was represented by counsel, he told the board that he was not raising mental health as a defense or as an issue. How do you get around that? Why should he be able to now, years later, raise it as an issue that he deliberately
Because it was
chose?
shameful to him. It is always shameful to those who suffer a mental illness to use that as an excuse. The letter that Dr. Chester wrote for them in 2019 clearly posited that issue directly before them, and I think they ignored it. I don't think Louisiana is as far as we are in Texas in dealing with mental health issues, but I think for the same reasons, you can't self-diagnose yourself. You can't expect a person who's suffering from mental illness not to feel shame and to own up to his or her obligations and responsibilities. We're not saying that he gets a pass. That's not what I'm asking you for. What I'm asking you for is that he has shown that he has the capability to work and represent clients successfully in Texas for a long period of time now, and he should be allowed to continue to do that.
Any other questions from the board? All right, thank you both for your
Thank you.
presentations and for being here. You are excused. The board will take this case under advisement, and we stand in recess. Thank you.